Well, breaking news. Welcome to 1974. This is what living through high-speed history feels like. 50 years ago, a Republican president of the United States was under investigation, and the federal courts in Washington, D.C. responded accordingly and appropriately. The courts worked faster than we had ever seen them work before. The breaking news of tonight is that the United States Supreme Court took only 5 hours this afternoon to decide to fast-track Special Prosecutor Jack Smith's request that the Supreme Court intervene now and decide Donald Trump's appeal in the case of United States of America versus Donald J. Trump. Donald Trump appealed a decision by the trial court judge, Tanya Chutkan, in which Judge Chutkan denied Donald Trump's claim of complete immunity from criminal charges for any conduct during his time as president of the United States, and his claim that he was immune from prosecution in the January 6th case because Donald Trump's lawyers say that that would be double jeopardy because Donald Trump already was subjected to an impeachment trial in the United States Senate on essentially the same charges. Last week, this appeal by Donald Trump seemed like business as usual in the federal court system, with the United States Court of Appeals in Washington, D.C. having jurisdiction over the Trump appeal with an unlimited amount of time to consider that appeal. And as I complained on this program last week, the appeals court could take a year to decide an appeal like that if they wanted to. And after the appeals court decision came down, the losing side was surely going to appeal to the United States Supreme Court, which could then take, who knows, another year. Jack Smith decided not to play that game. At 12:30 p.m. today, Jack Smith filed a petition directly to the United States Supreme Court, asking the Supreme Court to use its power to reach down and take this case off of the appeals court docket for immediate consideration by the Supreme Court. At the same time, Jack Smith filed a backup motion with the appeals court to expedite the appeal at the appeals court level if the Supreme Court refuses to take the case at this stage. And just 5 hours later, the Supreme Court responded favorably to Jack Smith, and a half hour after that, the Court of Appeals responded favorably to Jack Smith. The United States Supreme Court issued an order saying the court granted Jack Smith's request to consider taking the case on an expedited basis. The Supreme Court has not decided to take the case, but has decided to consider Jack Smith's argument that the Supreme Court should take the case. The Supreme Court then gave Donald Trump's lawyers until next Wednesday, December 20th at 4 p.m. to file a reply brief to Jack Smith's brief that was submitted to the Supreme Court today. And the United States Court of Appeals, which still has jurisdiction over the case until and unless the Supreme Court decides to take the case at this stage, issued an order to Donald Trump's lawyers saying that their reply to Jack Smith's request to the appeals court is due this Wednesday, the day after tomorrow, at 10 a.m. And in his petition to the Supreme Court, Jack Smith reminded the court of just how quickly the Supreme Court is capable of working. Quote, the district court overseeing one of the Watergate cases had scheduled trial to begin on September 9th, 1974. On May 24th, 1974, the special prosecutor sought certiorari before judgment following the district court's denial of former President Nixon's motion to quash a subpoena seeking Oval Office recordings. The court granted certiorari a week later and set the case for argument on July 8th, 1974. The decision issued 16 days later, and the trial began in the fall of 1974. Jack Smith showed the Supreme Court in that example that the Nixon case, one of the reasons they acted as fast as they did was to preserve the criminal trial schedule of the Watergate defendants in Washington, D.C. Jack Smith asked the Supreme Court and the appeals court today to expedite the appeal to help preserve the trial date, currently scheduled for March 4th in this case. Rule 11 of the United States Supreme Court says that an appeal can bypass the Court of Appeals and go directly to the United States Supreme Court, quote, upon a showing that the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in this court. Jack Smith uses that key phrase, imperative public importance, multiple times in his petition to the Supreme Court, beginning on the first page of his argument. And on page 10, Jack Smith writes, this case involves a paradigmatic issue of imperative public importance, the amenability to criminal prosecution of a former president of the United States to conduct undertaken during his presidency. It requires no extended discussion to confirm that this case, involving charges that respondent sought to thwart the peaceful transfer of power through violations of federal criminal law, is at the apex of public importance. The charges implicate a central tenet of our democracy, and the charges allege that respondent conspired to transgress the law in manifold ways by intentionally using fraudulent means to obstruct the presidential electoral process, by obstructing constitutionally prescribed processes in Congress for counting electoral votes, and by seeking to deprive millions of voters of their electoral choice for president.